This is Attorney Charles Green, and I'm a family law specialist here in Los Angeles, California, and I handle family law cases, divorces, domestic violence, and related topics. Today I'm going to talk briefly about domestic violence. Domestic violence is one of the largest filings in the family law system here in Los Angeles, as I understand. Makes up approximately 65% of the cases filed in the Los Angeles County family law system. So domestic violence is a big topic and a large part of the litigation involved in a family law practice. But there are several types of restraining orders related to domestic violence. There is the family law, CLETS, DVTRO restraining order. There is emergency protective orders, which are issued by police officers on the scene at a home in a domestic violence situation. And there are CPOs, criminal protective orders. And there's also a hierarchy to these family law restraining orders. So EPOs, emergency protective orders, will usually trump a restraining order that was issued by the civil court, the DVTRO. Okay? Criminal protective orders, CPOs, issued by the criminal court will usually trump both the EPO and DVTRO. But this is not meant to be legal advice here. This talk is just to give you a general understanding. So for each of your individual situations dealing with domestic violence restraining orders from a family law court, emergency protective orders issued by a police officer, or criminal protective orders issued by the criminal courts, you should deal with those by talking with an attorney and getting advice on your individual situation. But there is a hierarchy to those orders, and police officers and judges are usually aware of that hierarchy. And if you look closely on the forms, it'll talk about the hierarchy of the restraining orders. Okay, so let's start with the DVTRO. A DVTRO is a restraining order issued by the family law court, and it is usually issued ex parte, and that means that someone writes out a declaration and the court reads it as if it was true, and if everything stated in the declaration would cause a restraining order to be issued, then they will. And the restraining order is issued many times without notice to the restrained party. Okay. But what is of most importance to most people in my practice when a DVTRO is issued is the child custody components. And that's where I'm going to talk about for the bulk of this conversation, is the fact that if a DVTRO is issued to you at a hearing, and the hearing comes approximately 3 weeks after the issuance of the DVTRO, you will have a court hearing, a trial. But first you would have been served with the restraining order, so you know to go to your trial. At that trial, if the DVTRO is issued, if you are found to have committed domestic violence in the family law court, which means a 51% standard, more likely than not, 51%. Okay, so it's not like criminal court where it's like a 99.9% standard. It is a 51% standard. So it's not that difficult for someone to get a domestic violence restraining order against someone who is antagonizing them in some way. Harassment can be very simple. Harassment can be something like sending multiple text messages or multiple phone calls to your partner when they don't want to hear from you. You are affecting their peace, their tranquility. You are disturbing them. Okay, so if you are doing something that a reasonable person would think would disturb another person that doesn't want your contact, then you are committing harassment, which is a form of domestic violence. Domestic violence does not have to be physical. It can be physical, of course. Okay, it could be yelling. It could be messages. It could be a multitude of things. But the most important part of this, for most people, is how it affects child custody. The child custody is found in Family Code 3044, and it's called the Family Code 3044 Presumption. And it is a presumption against joint custody. So there is a presumption against you having joint custody of your children if you are found to be a perpetrator of domestic violence. So what is my advice to you? Do not fight with your partner, okay? If you fight with your partner, if you disturb their peace and harmony, their peace and tranquility in any way, if you assault them in any way, if you disturb them in their workplace, if you contact their employer and say nasty things, if you send abusive text messages, there are dozens of ways to commit domestic violence against a partner. Okay? If you do this, and a domestic violence restraining order is issued against you when you have children with that partner, there is now a presumption against you having joint custody. The courts invoke this presumption in different ways. Sometimes it will mean that you lose joint custody and your partner will have sole custody, but you still may have a parenting plan. Other times, if the children were present during the acts of domestic violence, you might have monitored visitation. Okay, and what do you do to correct the situation? Well, to correct the situation, you have to do usually parenting classes as well as a 52-week domestic violence class. All right? So the court will order you to do a 52-week class. You do the class, you go back to court after you do the class, and it is possible at that time that the presumption against joint custody could be lifted. This is, of course, something for the court to analyze, and each situation is different. But what should you get out of this brief talk we're having today? Domestic violence in the family law setting can really hurt your access to your children. So no matter how upset you are, no matter how angry you get with your spouse, stay calm. Stay calm for the benefit of your children. Do not perpetrate domestic violence. Think about your children when you get angry, and think about how you want access to your children and how it's in your children's best interest for you to be in their lives. And for you to remain in their lives, you need to not be found to have committed domestic violence. There are many other aspects to domestic violence restraining orders. They can be issued for 6 months, a year, 5 years. They can be renewed. A domestic violence restraining order can easily be renewed upon its termination if someone applies before it terminates. So the restraining order could go with you for many more years than when it's originally issued if the protected person goes back to court before the restraining order terminates and requests its renewal. And they don't need to show that you violated it. So it can be renewed very easily. Okay. Criminal protective orders will usually be something that is negotiated with your criminal plea if you plea. Okay. And criminal protective orders are of a higher priority than domestic violence restraining orders. So if someone has a criminal protective order, usually if they apply for a domestic violence restraining order while the criminal protective order is in place, or the EPO, emergency protective order, which is issued by a responding officer to a domestic situation, and that officer would usually be calling a judge and explaining the situation and getting permission to issue a 7-day restraining order. It could be a different period of time as well, but usually not very long. Long enough for you to go to court, the family law court, and apply for a domestic violence TRO on an emergency basis, otherwise called ex parte basis. Okay? So remember, we have DVTRO in the family law court. We have emergency protective orders, which are usually issued by family court judges over the phone to policemen who are responding to a domestic situation that is acute, and they're issuing a move-out order or some sort of protective order to the aggressive party. And then we have criminal protective orders, which are issued by criminal courts. And there are similarities amongst all of them. One thing you should know about DVTROs, the family court orders, is many times they will cause you to move out of your home against your will. So that can be very traumatic to someone, that they have to leave their home on very little notice, and usually all you can take with you is some clothing when you're served and the sheriff or the police officer is there serving you with your DVTRO, which usually had no idea this was happening, and they ask you to leave the home, and they usually give you a little bit of time to get your clothing, some shoes, and you will not be able to take many things other than personal items with you at that point. And you'll have to go to a friend or relative's home or a hotel, and it's a very traumatic thing to be put out of your home. But that's what happens to people who are perpetrators of domestic violence, and when the court believes the statement made in the restraining order application and issues it without notice to you, then, like I mentioned earlier, 3 weeks later you get your day in court, and that's when the temporary restraining order will either be dissolved or issued as a permanent restraining order for 6 months to 5 years. Okay, so I hope this information was helpful to you, and if you find yourself as either the victim of domestic violence or accused of domestic violence, the law office of Charles Green has a great deal of experience with domestic violence trials in the family law court, and we will certainly talk to you and see if we're a good match to represent you in the domestic violence restraining order trial. And in that trial, there are many ways to handle it. Because remember, in the domestic violence restraining order trial, which is what they call a summary proceeding, there are effectively 2 trials. There is the trial on whether or not someone committed domestic violence, and then there is also the trial within the trial on whether or not you're going to lose the custody rights to your children. Okay? And what will the parenting plan look like if you lose the restraining order and the presumption against custody is held against you? Okay. So if you want to talk to us here at the Law Office of Charles Green, please feel free to give us a call at 213-387-4508. We are located in the Mid-Wilshire area of Los Angeles at 3699 Wilshire Boulevard. Thank you very much. I hope this was helpful, and I look forward to talking to you if you should need our services.